Cross-border litigation has jumped tremendously because in 1991 India opened up. Everything started with joint ventures and technology transfer kind of agreements and the usual ones. But over a period of time we have seen a lot of private equity disputes. At this point in time we see that as a major segment where arbitrations are beginning to happen. Effectively, what I see is that documents are also getting more complex, and therefore specialized arbitrations are becoming important. Arbitrators need to know the industry in which, for example, construction is a very popular example. Similarly, in private equity, people need to know where they come from. A lot of people think that private equity brings billions of dollars and they have got a lot of money around and they can splash and do whatever. But if you really analyze behind private equity funds, who are the investors? Majority of them are pension plans, institutions, insurance companies, endowments, and so on and so forth. So if you look at pension plans, who is behind pension plan? A small employee. Okay? His monies are at stake. So the duty or the obligation of a fund manager is towards the end consumer of his services, that's pensioner. He has to create a return for his investment. The difficulty is that if pension plan monies, for example, are put in a bank, you get just nothing today. Sometimes you get 1%, 2% in dollar terms. Okay, if you're lucky, you get a little more. So how do you provide return over a period of like 20, 30 years? Because you're taken commitment that I'll repay you X amount of money, you put money in pension. Now they have to make up for the return as well. So they have to distribute the whole portfolio into steady returns, some in banks, some in bonds, some in stocks and stuff like that, and some in risky capital. Some of the universities in the US, I've seen they have about $16, $20 billion. So 5%, 3%, 4% are put up in venture capital funds, like Stanford puts a lot of money in venture capital. But if one Google comes out, who benefits? The pensioner. And that's how you manage the returns. But what happens is that when investment is made on a global basis, you see these are sometimes complex structures and complex systems and stuff like that. And eventually you have to resolve them and get exit, because exit is all about private equity. So lately we have seen a lot of litigation in the private equity space. Second thing is if you look at the regulatory framework, unfortunate part in India is that when we draft laws, I think they are unfortunately very poor quality. At one point of time, our standards were perhaps the highest in the world. Lord Macaulay, who drafted the Indian Penal Code or Indian Contracts Act, how many amendments we have seen after 150 years? Very few. How much, look at the conceptualization of the visualization, articulation, and then drafting. It took good 5, 7, 10 years to develop that law. But once it is in place for 150 years, you don't need to touch. Today, you take most of the laws, today you announce something and tomorrow you begin to change, and sometimes you, change it with retrospective effect as well. In tax, we are very much used to this retrospective amendment. It is very strange. Many countries have banned retrospective. About 12 countries in the world have banned retrospective amendment if it adversely affects a citizen. And as a result, new issues keep on arising, as like call and put option and stuff like that, which RBI considers as more like a debt instrument and stuff like that. For years together, they didn't say anything. Suddenly, one fine morning, they wake up and begin to change. That third party brings a lot of disputes between the parties, and therefore arbitration has, I think now, assumed an important role. Going to the court, what happens? We have close to 66,569 cases pending in the Supreme Court. We have 42 lakhs of 4.2 million, 17,903 cases stuck up in the High Court. Okay, so maybe, I don't know, hundreds or tens of years will be spent in litigation. You never get out of it. I think, of course, it helps our community as lawyers. It gives us perpetual employment and perpetual, income stream. But that's something not very exciting in that sense. At one time, we used to see a lot of ad hoc arbitrations, and now institutional arbitrations are coming up, which is a great thing because you have more system, more process, more organized way of handling these arbitrations, and that is something which is very, very helpful. SEAC, LCIA, and some other institutions have really, I think, have created tremendous amount of awareness as well. And at one point of time, we used to look at Paris and other countries, but I think other places. Today, I think Singapore, London have become very common. At times, interestingly, in a couple of cases, our experience was that instead of the cases of interim injunction, we found that instead of going to Delhi and getting injunction, it was better to take the whole team to, say, Singapore. Okay, go to Singapore court, stay there with the whole team, engage counsels, lawyers, and come back. Was faster, cheaper, and better because it just happened on time. Within one visit, you could finish most of the things, and the courts and the institutions use technology to a great extent so that, for example, when we went there in the Singapore court, you get SMS. They treat litigant as a customer. Okay, service is an important function of judiciary as well. Whom are you serving? You're serving the citizens. You're solving the problem. So you get SMS, you get email, you can file. And the hearing is only for a limited period of time. It comes up at exactly the time when you're told, and it finishes. Okay. Somewhere along the line, we'll have to really bring about some changes in Indian legal system as well. But this is not the subject of my discussion today. All that I'm saying is that arbitration is assuming a lot of importance. As we can see, in terms of institutional arbitration, SIC had, I think, over 235 new cases in 2012, close to 25% increase compared to previous year. LCIA has the highest number of cases with 285 cases registered in the year 2009 and stuff like that. So I think this is becoming an important part of the even judicial system. Obviously, our law was upgraded to be in conformity with the Nishith, and a lot of improvements have happened. I do not want to really take away the steam from other speeches that are going to be happening here in the course of the day and tomorrow. But one of the interesting things is that if you introduce judicial reforms, it can increase GDP by almost 1.5 or 2%. That's what is, a study, what's called from the Judicial Impact Assessment, and India Development Foundation with that study. So it really helps to, improve productivity, improves the efficiency of the whole system. And Indian judiciary has been trying to be very proactive through a series of judgments, and we have seen interpretation of the acts, but still, I think most sophisticated investors prefer to go for an arbitration. Of course, bilateral judgment, I don't want to talk about it again at this point in time, but it's a step in the right direction. I think in the course of the day today and tomorrow, there will be a lot of discussion. I'm sure you'll enjoy this conference. I wish you all the best. And we will also be touching on commercial arbitration plus BIT. What we have seen lately is there is upsurge in bilateral investment treaty issues. I believe last year at least 5 or 6 BIT arbitrations came about. Never before in the history of India. We always thought India was the safest country to bet on. Okay, we only thought some African country or some island somewhere in, I wouldn't talk about Maldives and stuff like that. But only there this kind of stuff happens. But what we saw, India is facing those situations. So we thought it would be appropriate to discuss issues, nuances concerning the bilateral investment treaties. They have become extremely important, especially now that India is growing global. Okay, Indian companies are expanding outside, and BITs are very, very important. And finally, we have also taken some initiative in talking about international arbitration in the taxation matters. If you look at tax revenues are held up so much, in litigation. On the one side, we continue to hear that government keeps on collecting more and more taxes. On the other hand, the litigation, shows us that almost 80% of the cases are lost by government. Just on transfer pricing litigation, 50,000 crores were held up, just about a year and a half ago. So today it must be a lot more. Now, if you just take that example, I'm not talking about other types of litigation tax. So close to 80%, if you count, 40,000 crores are held up in tax litigation. This tax has been collected possibly without the due authority of law. So what happens after 5, 7, 10 years, when the taxpayer wins the case, government has to refund this money with 6% interest. Okay, what happened in Vodafone? Let's see. Okay, the council, special counsel for that. But if you look at from the economic perspective, the amount of tax that was collected had to be refunded. Normal interest that tax department is to pay is almost 6%, in that case 4%. But on a dollar amount, when the rupee was stable, you paid 4% interest on less than a year deposit, right? So you can imagine that government is undertaking so much debt obligation, and this is in a sense a guaranteed return by the government, because law provides for that. It's a borrowing by the government. So you can imagine on 40,000 crores that are held up in this litigation only on transfer pricing, maybe other thing I'm not talking about. That means government has borrowed 40,000 crores. But this never gets reflected in the budget. Budget never shows up that how much tax has been collected and has been in the courts or in the litigation. So you are creating internal debt in some sense. This is nothing else but equivalent to what I would call issuance of, informally, issuance of sovereign bonds. Because you have taken people's money and then you have to refund it with a guaranteed statutory interest of 6%. And there also there is a great need for arbitration. Because otherwise how long people will litigate, 10, 15, 20 years and then stuff like that. So, we are trying to take more holistic view of this arbitration gamut and see that we can discuss these issues and see that we can resolve problems Problems always come, but solutions are more important. So they always say that